Welcome to the Vicca Law podcast, Protecting Legacies, Resolving Conflicts. I'm Lidia Vicca, Director of Vicca Law, where we specialise in succession law, civil disputes and litigation in Queensland. If you want to safeguard your assets, navigate estate planning with confidence, or resolve legal conflicts effectively, you're in the right place. Join me each week as we break down complex legal issues into clear, practical insights, helping you protect your legacy and find solutions with certainty. Let's dive in. Hello and welcome back to the Vicca Law podcast, Protecting Legacies, Resolving Conflicts. I am your host, Lidia Vicca, Director of Vicca Law. And here we are in the month of August. What a wild ride it has been so far. So if you caught up with all the podcasts last month, we were really going through kind of a different track, I guess, the QCAT process and disputes, and also launching my course that I created to confidently handle claims in QCAT, allowing people the necessary guidance that they need to get through the QCAT process, which is very exciting for me. But we are headed back into the Protecting Legacies side of the podcast this month. And this month we're talking about probate and letters of administration. And I definitely want to talk about this topic because I think there's a lot of misconceptions out there about what probate is, and it is very different to the other states. That's the other thing. So probate and letters of administration. That is an order that you apply. So you apply to the court for an order that the last will is the valid will. This is for probate, and that the executors named in the will are the people authorized to administer the will. Okay, that's probate. Letters of administration is similar, except you apply for letters of administration. Sometimes you apply with the will if there's no executors, but a valid will. So a will might have executors listed, but they have predeceased or they've renounced for whatever reason. So you might apply for letters of administration with the will. Sometimes that is required in a will if the first executor is unavailable or has renounced. And then, of course, the number one reason you might apply for letters of administration is where there is no will and the person has died intestate, which means they have died without a will. And so the letters of administration is applied for by the person that has the highest priority to the estate in accordance with the Uniform Civil Procedure Rules, 1999 in Queensland. And then they have the authority as the administrator to administer the estate of the person that has died without a will. So once you have those two documents, and I'll just briefly say how you get them. First step is you need to advertise in the Queensland Law Reporter to say that you are going to apply either as the executor under the will or as the administrator under letters of administration. 2 weeks after that, you can then make an application to the Supreme Court. And in that application, you have an affidavit of advertising. So that's done by the solicitor, whereby we say we've done the advertising, we've notified the public trustee, and also an affidavit from the executor or the administrator, just saying that they are the appropriate person to apply and that they are of good standing, a few requirements that are in the UCPR. Then once you apply for those documents, they're lodged with the court now online, and the original will gets filed by post. That's how I do it in my firm. And then I want to say 4 to 6 weeks, but there's been a bit of delay recently. So I would say between 4 and 12 weeks later, then you get the order of a court. And that's called a common form grant of probate or of letters of administration. And that's the usual process. We will talk later on in week 4 about maybe an unusual process. I've also talked about challenging a will and solemn form proceedings, I think in June maybe. Essentially, that's the process for probate. Now, when do you need probate? That's the question that everyone asks me. And the number one misconception is when people come to me for estate planning, they say to me, I don't want it to go through probate. I don't want to have to go through probate. And I don't think anyone has a real understanding of what the process is and when you need probate. So in Queensland, there are a couple of instances where you will need probate of the estate. Number one reason is there's a refundable accommodation deposit coming from nursing home. or aged care facility, they will not release that refundable accommodation deposit without probate. So, by way of example, for those that don't know, when you go into a nursing home or a aged care facility, a private one, you're required to pay a refundable accommodation deposit, which usually secures your place. And the nursing home uses those funds to essentially they earn interest on it, and it's completely refundable. It's guaranteed by the Commonwealth Government. But those are very high values. So the smallest one I've seen is about 180,000. The largest one I've not seen but heard of is around 1.2 million. So huge amounts of money. So that is a number one reason why people get probate. The next reason will be where there's bank accounts that have significant amounts of money on them. Don't quote me on this because literally every bank is different and it changes constantly. It's so frustrating when clients come to me and ask me, but I just can't tell you because every bank is different and every internal process is different. But any value around 30,000 plus requires probate, so the banks won't unfreeze bank account. That's bank accounts in the sole name of the deceased, not joint accounts. They vest automatically in the joint holder of that account on death, but for any personal bank accounts. So quite commonly, we will definitely be getting probate when the second of a spouse has passed away. Generally not the first, but usually the second. Another common reason is shares, share values that are quite high. I think it's over 5,000. Again, don't don't quote me on that one, but around that mark, they will require probate before you're able to deal with those values. And I'm trying to think of other reasons. When there's multiple properties, that would be the other reason. Where there's a number of properties that need to be transferred under the will, we will get probate or letters of administration for that. So, and the reason that we do it is because all those institutions, all those places want to know that when they're handing over the money or the shares or transferring the property, that you as the executor have the appropriate authority to deal with the assets of the estate. And that's how it kind of works. That's why people want probate. Now, there are actually a number of instances where you don't need probate. And most commonly, it's because the value of the estate. Oh, sorry, I forgot to mention one other thing. Super. Sometimes superannuation funds, depending on who's the beneficiary nominated, will also need probate. So if the person has nominated the legal personal representative, they'll usually want probate. If there might be a gift of the super under the will, which is different to the nomination, they might also want probate. There are a number of circumstances where you don't need probate. And the main time that we see this is when, the value of the assets aren't that great. The other time will be where there's a number of debts of the estate because the executor takes on the debts. And quite often, if there's an insane amount of debt, no one will apply for probate because no one wants to take on that burden. And the other one is where it's usually a first spouse in a couple has passed and a lot of the assets are joint. Most of the time, if it's a joint tenancy in a property, that's a record of death, doesn't need probate. If there's bank accounts held jointly or shares held jointly, they all go to the surviving holder of the shares or that bank account, so you don't need probate. And the other circumstance might be where there's only one property and it's transferred and you can use the will to do that with the titles office. You don't need probate either. So that's why when people call up and ask me about probate, we go through the assets of the estate first up to determine if it's needed. Sometimes it's really hard for people when they are an executor to an estate where they just don't have a great understanding of what the assets might be to try to figure out what they are. I work with a wonderful lady, Danielle Phillips of Sage Executor Solutions. She really helps there. But we did have an instance quite recently, actually, where the will seemed to allude to quite a significant amount of assets. But when we went digging, there actually wasn't a lot. And so we started the process for probate, but actually didn't need to apply. So it's really dependent on the assets. Now, that's very different to other states. So a lot of people say, oh, don't you need a list of the assets? You do in New South Wales and Victoria, but you don't in Queensland. We're very lucky. I think we're very lucky. It's a one fee. In the other states, you actually pay based on the value of the estate, and they actually use it as like a money generating. It's just a one fee. So it's quite a simple process. You can even get a fee reduction of the fee if you have a seniors card or a gold card or anything like that. So that's a good overview of when you might need probate. Now, if you are unsure, the number one thing you need to do is consider the assets, and a lawyer can help you. So you can hop on my website, www.vicalaw.com.au, book a free consultation with me, Lidia Vicca, and we can go over the assets of the estate. If you have a will and you're uncertain whether probate needs to be required or there's something that needs to change in your will, also book a free consultation with me. This is something that I'm more than happy to go through with people. So next week we are going to continue with our probate journey of what you do when there are problems with the will, which is a very common scenario. So thanks so much for tuning in again, and I will see you next week. Bye. That's a wrap for this episode of the Vicca Law Podcast, Protecting Legacies, Resolving Conflicts. I hope you found today's insights helpful in navigating your legal journey. If you're ready to take the next step in securing your legacy or finally dealing with your dispute, you can pop on my website www.vicalaw.com.au to book a free consultation with me, Lidia Vicca. You can also subscribe to our newsletter or find out more about today's topic. Your future begins now, and we're here to guide you every step of the way. Until next time, I'm Lidia Vicca, signing off. The Vicca podcast comprises general information and does not serve as a substitute for professional advice. Prior to making any legal decisions, individuals are advised to seek independent professional guidance and assess the suitability of this information for their own individual goals and objectives.